Welcome to the BBB National Programs podcast, Better Series, where we will explore top-of-mind topics and self-regulation with business and industry leaders. Together we seek to understand the leading trends and innovations that continue to push the envelope in today's marketplace.
Thank you for joining us today on the Better Series podcast. I'm James Lee. You may not have noticed it between parades and football games, but there was a seismic event on New Year's Day. It fundamentally changed the way we view privacy in the United States. The California Consumer Privacy Act, or CCPA, went into effect requiring businesses to give California residents an unprecedented level of access to and control over their personal information. January 28th is National Privacy Day, and we're taking a close look this month at two issues of particular importance to businesses of all sizes and types. We'll examine the unique issues surrounding data privacy for children in one episode, and today we're going to look at the issues of consumer data access and control. Coben Zweifel-Keegan is the Deputy Director of the BBB National Program's Privacy Initiatives, and John Brescia is the Vice President of the BBB National Program's Digital Advertising Accountability Program. They're joining us today to talk about what the CCPA means to businesses inside and outside California. Thanks for joining us today, guys.
Yeah, thanks so much, James.
Yeah, thank you.
Well, let's get started. I mean, this is a rich vein we can mine for a while, but I'll start with you, Coben. You know, privacy is one of those topics where just about everyone has an opinion. How do we get to the point where the CCPA becomes the strongest privacy law in the United States?
Well, that's a very good question and a very long story if we want to go into a lot of detail, which we won't on this podcast. But I think to talk about where the CCPA originates, you have to think about some of the trends that we've seen over the past decade toward respecting consumers' rights to control and have more ownership of their information. And so in the United States, we've had historically a more sectoral approach to privacy, and California just happens to be the first state to take a jump towards a overall approach to privacy, towards treating all data the same, regardless of whether it's collected online or offline, and regardless of the industry sector that it's originating in.
In doing that, you know, this is a trend California kind of started, didn't they? If we go back to 2004, 2005, they really sort of started us down this path in the U.S. With the breach notice laws, didn't they?
Yeah, they were one of the first to adopt breach notification laws, which now are all over the country. So that's a good point and kind of points to the fact that they traditionally have led the way with a lot of consumer protection issues, and also highlights the fact that we may end up with additional privacy laws, just like we have with data breach notification laws, as other states try to emulate the rights that California consumers are enjoying after this law went into effect.
Well, let's talk about that, what those rights are, because this is a fundamentally different kind of approach to privacy, as you noted. So I'm in San Diego today, and I walked into a bagel shop this morning, and there in the window before you walk in was a poster that said, Notice of Consumer Information Collection. So that's part of the CCPA. You know, the consumers get more information about what data is being collected, how it's being used, et cetera. But by definition, if consumers have more rights, that means businesses have more obligations. So what is actually being obligated in the CCPA? And who is it that's going to get these actual rights that are being created?
Sure. So this is John. I'll jump in on that one. The CCPA, as a state law, applies to, in this case, California residents. And what's interesting to note about that right out of the gate is that it appears that it applies to California residents regardless of where they are. So you can be a California resident and be on vacation or spend a month working on a contract in a different state. Seems like you're still covered by this. And it confers, this statute does, and I should say the regs are also out for people to reference, so there's two parts to this, but rights of notice, access, deletion, opt-out, non-discrimination, And there's additional work around the edges with the data security breach notification piece, where they're elaborating on their existing data breach notification posture legally to allow for private rights of action in the case of breaches. And that's the only place where that exists. And we can go into as much or as little detail as you want on any of those specific points.
Yeah, and I think your story actually is interesting with the bagels store, because I think CCPA does apply both to online and offline collection of information. So I think the bagel store is taking a very real look at the law and realizing that they do possibly have an obligation to inform people that maybe they are collecting and sharing information.
Yeah, and to be fair, businesses have been doing something like this for years when it comes to in-store surveillance, right? Notifying people that they're on closed-circuit television that's being recorded, notifying people more recently if there are tracking beacons in their stores, Bluetooth beacons or Wi-Fi beacons that note where shoppers are going to construct heat maps of activity in a store. They're frequently disclosure placards that tell people about that. Always? No. So this is a much more systematic approach to deploying these sorts of things, in the retail space, or at least that's what I'm expecting, is you're going to start to see more and more of those, pointing people almost certainly to the company's website where the notice will be placed. And there are a lot of things that in CCPA tie into a company's website. There are alternative physical disclosures you can give people. Think when you sign up for a cell phone line or something, and all the sheaves of paper that you go through to sign. But I'm guessing that standard commercial situation's actually going to be very similar to what you experienced.
So that's a very broad law you just outlined there, John, with a lot of moving parts and a lot of components. And this particular law, was passed a couple of years ago. There were some amendments made in the second year by the legislature. As you said, the regulations have now been proposed. This is pretty complex for businesses to understand. What are the key points they need to make sure they're focusing on today that they don't get into trouble?
So, Coben, I guess you and I can sort of trade off on this as things occur to us. But, the number one thing is, of course, and I think this is just the best practice generally, whether it's for CCPA, GDPR, any, internally motivated, privacy regime, whatever it is, you got to know what you've got, why you've got it, where it comes from, what you're doing with it, where it goes. Things like that. What data is even in your business? If you ask a business today what they've got, there's a good chance many of them can't tell you what they've got, not in a really thoroughgoing way. And it's important to note that this ties directly into CCPA for the access and deletion rights that people get. And this is a really vexing area for businesses, as I understand it. Someone contacts you and says, "Dear business, pursuant to this legal regime, I have the right to have all the information you've got on me. Give it to me. Tell me what you have about me." How do they know who that person is? How do they verify the identity of this person? What data internally is linkable to this person? What reasonable efforts do they have to make to link that data to this person? This is all very fuzzy stuff. And so that's an area where a lot of energy goes to figuring out what is the reasonable approach to compliance here.
Yeah, and I think that's where we're seeing a lot of discussion among businesses about the difficulties that they are having in coming into compliance with this law, or at least aligning their practices with CCPA and thinking proactively, hopefully, about other privacy legislation that may be on the horizon. It's been important to start thinking through some of these practices, and I think we haven't yet seen all of the standardization that we will probably see very soon in terms of how to implementation. There's a lot of vendors, there's a lot of options for companies that do want to make strides in terms of adopting best practices, but especially once you put it into a law, it sort of ossifies it a little bit, and yet suddenly you have strict requirements, but in the case of the CCPA, not necessarily specific requirements that leave it open to interpretation in some instances. Like, for example, the CCPA requires a notice. You have to add a notice to your website. If you're collecting data online, you have to make it upfront a button that lets you opt out, a do not sell my information button.
And that's only, by the way, if you sell the California residence data to third parties, sell being defined very broadly in the statute. You may not think of yourself as being a data salesman, but perhaps under this statute you are.
Right, exactly. Right? Yeah, and Yeah, so already you're kind of up, and
It's
you've seen
confusing
privacy
out of the
policies,
gate, right?
And you've seen a lot of website notices and privacy policies sort of wrestling with this, as many companies have said, well, we don't think we sell your personal information, but California thinks that maybe we do. So insofar as we sell your personal information under California, you can ask us not to by clicking this button. But a lot of companies have asked the Attorney General of California, who's implementing the legislation, the AG has asked for feedback, and there's been a comment period. We heard by actively engaging in that, we've heard from businesses they would really appreciate there to be standards in the button design, just even in terms of design or and exactly how it's expected to function. Any standardization around that would be really helpful, because otherwise you might end up with a proliferation of different ways of doing it, which could be fine, but may cause problems down the road, especially as more laws come into effect.
And that's absolutely it, right? If we have other jurisdictions passing somewhat similar laws, then you have to start to say, well, which of these pass muster under California and also comport with Washington State or Texas or wherever it's going to happen.
And I do want to come back to that, because that is almost inevitable at this point. The only question is to what degree they either try to one-up California or they just kind of follow in their wake. But this concept of the do not sell button, that's one of the things that a lot of consumers have kind of, it's easy for them to visualize, but now that it's being implemented, everybody has their own view of how to do that. Some of it's very obvious, some of it's very subtle. But it all goes to the same point of disrupting what has been the marketplace, if you will, because this is all aimed at giving people control over what data is used for marketing. In December, we had two marketing experts on the Better Series podcast, and one of them used the term cookie apocalypse as a result of the European privacy law, the GDPR, and its effect on the marketing world. And now everybody's waiting to see what happens here in the U.S., because under CCPA, if people opt out of the ability to sell marketing data, the idea is this could be very disruptive to that the advertising and marketing space. Now, John, I know that's your world, digital advertising and accountability. So what is it that you believe we're going to see in this marketplace now, and what do you think that the law, the real impact of the law is going to be?
Sure. So, at this point, there are, I'm going to say three things that I think I can comfortably say. The first thing is no one knows exactly what we're going to see. It's highly provisional. We don't have the final regs, even though the telegraphing from the AG's office is that the draft regs basically are the final regs. But that remains to be seen. It's not done till it's done. And so then we've got to look to, well, what's going to be considered compliant under those? And that's an ongoing process, right? That's like saying, well, what's a Section 5 violation? Or does this particular property fall under the domain of the Children's Online Privacy Protection Act or something like that? Those are questions that get asked and answered on a continuous basis. So I can't prognosticate about what the single ultimate final answer is in that. Don't know. But what I do know is that adaptation is going to be the rule going forward on this. People are going to be trying out, as we've just discussed, a variety of compliance strategies. So I, for my primary work, enforce the Digital Advertising Alliance's self-regulatory principles that deal with targeted ads on the internet. That same outfit has recently put out some compliance tools. A new icon that looks like their old blue ad choices icon, but it is now in a refreshing California green, and is meant to signal that California privacy rights and potentially other privacy rights for other state jurisdictions as those come online, if they do, can be found through this icon. It's a signal to consumers, hey, here's where you can learn about your privacy rights. And then they've built a version of their opt-out tool, which is traditionally, it's been around 10 years or so now, has traditionally been an opt-out from interest-based advertising on a company-by-company level, pursuant essentially to the terms of their principles, right? There's a new page that functions the same way, but that is meant to effectuate the do not sell my information requests. This is sort of aimed at the publisher end of things, the website owner or operator end of things. And so this is a potential compliance solution for them, and those tools are out there as of this week. We also have, like, the Interactive Advertising Bureau has put out their framework for how they think, the ad tech third parties, for example, could grapple with this. And so that involves sort of borrowing logic from Europe in a way, like a binding model contract scenario where you have standard form contracts that everybody signs on to that set out the terms, basically recapitulating anyone who signs this contract follows California law. You've got to follow the law. Here are the requirements. This matches the law. I'm going to do it. Now everybody's on the hook contractually, and then they're developing and they're moving in the direction of better technical standards for identifying people and making sure that do not sell requests are properly effectuated. And those standards have been released. I don't know if we're still in a comment period, if they're final. I feel like they're final, but don't quote me on that right now.
Last question for both of you, because clearly this is going to evolve both in California, and those impacts are going to ripple. But what do you think we're going to see across the country? Virginia, just this week, lawmakers there said they're going to propose a CCPA-style privacy law in Virginia. You've had New York signal the same thing. You actually have New York passing a law late in the year which strengthened their breach notice law, turned it into a cybersecurity law along with a privacy law, and they're going to go for a second bite at the apple this year. You've got a number of other states talking about it. So what do you guys see as what is going to happen as this works its way through the state legislative process this year and then ultimately the federal legislative process?
Yeah, I think that's a good question. Obviously, looking to the future, we're seeing movement on both of those sides, on both the state level and the federal level. I think it's important to remember first that just because the CCPA is the strongest privacy law, that's the argument. The
strongest general purpose privacy law in the United States.
Right, exactly.
I think it's fair to say.
Just because that's true doesn't mean that it is a gold standard in privacy law. And I think it's gotten a lot of flack for the fact that it was drafted very quickly, that it has some internal inconsistencies, and that it's focused on certain consumer harms. It's definitely focused very much on this idea of selling people's information, but it doesn't necessarily encompass some other things that consumer advocates are very concerned about, especially certain types of collecting certain types of information, like biometric information. It doesn't really distinguish between types of information very much.
Yeah. And Coben, to piggyback on that, I mean, that's why we're seeing draft CCPA 2 language, right, coming out of California, where advocates are saying maybe we need to go ahead and strengthen this right away. We haven't even gotten to compliance with the original one, and there's proposed not even amendments, but essentially like a wholesale rewrite.
Right. So there's really discussion on both sides, from both on the industry side and the consumer advocate side, in terms of how this law could be made better for everyone, whether through other states or in a federal law. I mean, the one thing that can be said for CCPA is it certainly kickstarted a lot of the discussion on the federal level in terms of saying, well, we don't want 50 different state laws that aren't going to be compatible with one another. So maybe we should have federal legislation.
Well, it sounds like we're going to be talking about this all year. So I appreciate John and Coben, all of your remarks today and coming and discussing this with us and helping educate us on what's going to be a lengthy process of everybody getting used to. And I want to thank all of you for listening today to the BBB National Programs Better Series. Don't miss an episode by subscribing to the Better Series by visiting our website, bbbprograms.org, then click on the podcast tab. You'll find all of our episodes there, where you can listen on your Apple Podcast app or your favorite streaming platform.
You just enjoyed the Better Series podcast. Be sure to tune in next time for a brand new episode. To learn more about our other shows, visit betterbusiness.blueberry.com. That's betterbusiness.blueberry.com. Follow us on Twitter at BBB_NTL programs. Send your comments and ideas to podcast@bbbnp.org. The thoughts and opinions expressed on this podcast are the views and opinions of the guests, not those of the BBB National Programs or its affiliates. This podcast is for information and educational purposes only and is copyrighted with all rights reserved. This podcast is protected by Blueberry's Terms of Service.